but we're going to focus mostly on the marriage part of the prescribed book. If you notice, I'm getting a bit sidetracked in between. I'm just trying to let some people into the meeting because Sean hasn't joined us at the moment. I'm just adding some people. Perfect. Okay. All right. So the book, to my mind, is in two halves. The first half being the part dealing with the engagement and the marriage, and the second half dealing with divorce, maintenance, and children. So what we've done is we're doing two sessions. Tonight's one will be about the marriage side of things, and then tomorrow evening we will do the divorce, maintenance, children's part of the book. I may not necessarily be able to get through every single item and concept, but I'm going to try and get through as many as I can. So the session tonight is really a Cliff Notes version just to brush up on a few key aspects. You still need to have read the book at least once, I would say. I've read it about 2 to 3 times already. And each time I read it, I do get a bit more information than I had previously. So although hopefully tonight does help, don't rely just on what I'm talking about tonight, because there's obviously quite a lot of information in the prescribed book. Let me just add some people in there. I'm not sure if you guys can see the lobby, but if you do get a notification there, if you can just let the guys in as they come, because I see some are not using their UNISA account, so it just shows them as being from outside the organization. If you can just let them in, I'd appreciate it. All right, I've got a couple of questions, about a dozen or so questions from the mock exam site that I took screenshots of, and if we have some time tonight, I'd like to go over them just for a bit of practice. The exam for this one is an MCQ exam, so at least from that point of view, it is a little bit easier. We don't have to try and memorize loads of things and then make very fancy essays like we had to do for constitutional law. So at least this will be a little bit easier. I see someone saying the volume is a bit low. I'm just checking on my side. On my side, it's telling me my microphone is at full volume. Can anybody else, can you guys hear me all right? Okay, perfect. All right. Okay, so let's just dive in quickly. I'm going to try and stick to our hour. So let's see if we can try and finish about 8 o'clock or so. Obviously, if people would still like to ask questions, what I'll do is I'll end the session at about 8. And then those that do need to carry on with their evening, you guys can carry on with your evening, and I'll stick around for those that do have a few other questions. It is being recorded. So what I'll do is once we finish with the session, I'll upload it to YouTube, and then I'll share the link in the WhatsApp study group. All right. Let's just jump straight in. I was going to start off with engagements, but I think I'll leave that one till the end of this session. I don't think it is as important as the marriage side of things or the past paper questions that I've gone through. I think I've maybe seen 2 or 3 questions with regards to engagement. So there's not a lot of questions. I don't want to waste too much time tonight on the engagement side of things. I'm going to jump straight onto the marriage, and then if we do have time at the end, I'll then recap over the engagement requirements, etc. All right, so let me just stop sharing that. All right, so let's start off with the legal requirements for a civil marriage, or at least the 3 types. We'll start with those. So the main ones are the civil marriage and the civil union. There are a lot of questions that seem to relate to those 2 particular types of marriage, and the other 2 being a customary marriage or a religious marriage. Now, out of those 4, only 3 of them are legally recognized, and that's the civil marriage, the civil union, and the customary marriages. Those 3 are legally recognized forms of marriage. And the religious marriage, unfortunately, there is no legal framework or regulation for those types of marriages. So those will be like your Jewish marriages, the Hindus, the Muslim marriages, etc. Those all fall under the religious category of marriages. There's no legal framework that specifically recognizes those forms. So the civil marriage, the key thing with this one that differentiates it between a civil union is that it's between a man and a woman. So this is for a heterosexual couple, a man and a woman. whereas the civil union can be any two people. The wording specifically says two people who are over the age of 18. So if you get any questions asking about the type of marriage that people can get or the type of marriage they can use, it just depends now, obviously, on their gender. So if they talk about a man and a woman, we'll be talking about it can be either a civil marriage or a civil union. But if you've got two same-sex people as a couple, they won't be able to have a civil marriage because that's between a man and a woman. They would have to then have a civil union. So if you get a question asking something like that, just remember that a civil marriage is only between a man and a woman. With regards to customary marriages, I've left that to the end as well. There are quite a few. The overall requirements are pretty much the same for a civil union, a civil marriage, and the customary marriages. So I'm going to start off with the civil marriage first because there's a lot of content specifically for those or for that type of marriage. One of the other things they'll ask you about is like legal requirements. I've seen a couple of questions. It seems to be quite a popular question. They'll ask you, what are the requirements to marry? There's a couple of them. The first one is the capacity to act. The second one is consensus. The third one is lawfulness. And the last one is the prescribed formalities. So those are the four main requirements, legal requirements for a marriage. So the first one, capacity to act, we're talking about the person being legally able to make decisions. In this case, we'll be talking, for instance, on a mentally ill person. They can marry, or perhaps people that are under curatorship, they can also marry. So if you remember in PVL2601, mentally ill people are able to have lucid moments. So if a mentally ill person is having a lucid moment, they can actually conclude a marriage, which is quite interesting, a whole another rabbit warren down there. But yes, you need to have capacity to act, which brings us to minors. Can minors marry? Yes, minors can marry, but they are subject to certain conditions that need to be met. I'm not going to go through all those conditions here because it takes up quite a lot of time, and then it'll just be rote reading off what's already in the book. So if you want to know the exact requirements for that, you can go and read that in that particular section of the book. But it is important that our first requirement is they need to have capacity to act. I see a hand up there. You got a question for us? You'll just have to unmute your mic there.
Yes, I do. Good evening, everyone. So, Darren, I'm a little bit confused. You said that, can you please just explain that whole civil union and civil marriage thing? The difference is that the union is between male and female. Am I correct?
That's correct. So a civil, okay, not the civil union, the civil marriage. The civil marriage is between a man and a woman. And the reason for that is if you go through the formal sections in the Marriage Act, there's a section there where the marriage officer has to ask them a certain questions. And it's usually, you know, will you take this man slash woman as your husband slash wife? So that actually genders the civil marriage civil marriage. It genders a civil marriage between a man and a woman. So you can't have two men or two women getting married under a civil marriage. Whereas a civil union, it says any two people over 18. So it doesn't matter if it's two men, two women, a man or a woman. It doesn't make any difference. So for most people, I think if they're heterosexual, they are going to get married under a civil marriage. But if they really wanted to, I mean, nothing's stopping them from being married under a civil union and being calling it a civil partnership or whatever the case might be. But yeah, if you've got two genders the same, they have to have a civil union. They can't do a civil marriage.
Okay, thank you.
Cool, 100%. Right, so okay, so capacity to act. Whoever's getting married, the parties to the marriage, they have to have the capacity to act. Otherwise, they're going to have a problem with the marriage. There'll be a defect in the marriage, and then it'll be a voidable marriage. The second requirement is the consensus. So do the parties agree to be married? There can be a problem, for instance, a defect with regards to consensus if there's like a mistake. Maybe you thinking this is just a joke and you say, I do, and we're signing some paperwork. In your mind, you thinking, I'm just doing this for a skit on YouTube or a video or something like that. So there's no consensus in that scenario because you don't have the consensus or the intent to be married, and therefore the marriage would be voidable. The same goes for misrepresentation or duress or undue influence. Those would all be a problem because there's no consensus there. So if you have mistake, a misrepresentation, a duress, or undue influence, any one of those four will make your marriage voidable because there's no consensus there. Let me just click that. And then lawfulness. I'm not sure if you guys have read that section talking about lawfulness of marriage. For instance, consanguinity and affinity of relations, or perhaps if there's another existing marriage. So if there's another existing marriage, then there is a lawful impediment to you being married. So you can't have two marriages simultaneously, for instance. Even a customary marriage, you have to get permission to do a secondary and a third, etc. Marriage. But for here, I'm just going to keep it simple and just call it marriage. So if you already have an existing marriage, then you're not going to be able to be marry another person because you already have one. You can only have one civil marriage or one civil union. You can't have two of them. The other key factor here is that affinity of relations. The first time I saw that in the book, I had to wrap my mind around that, working out these family trees and how does everyone relate to everyone. But basically, it boils down to the fact that you can't marry anyone in your direct line or the affinity direct line. So the affinity meaning by marriage relations. So if you marry someone, that person's direct line becomes your direct line by affinity because it's by marriage. So if your partner or your spouse, for instance, has a child, you can't marry that child. You can't marry your spouse's mother, grandmother, etc., because they're all in the direct line. So when we're talking about lawfulness of marriage, you've got to remember that there are certain degrees of I think they call it consanguinity. Oh, you'll have to forgive my pronunciation on that one. But there are certain relations that you cannot marry. So the two main ones here, is there an existing marriage and can you lawfully marry that person? So for instance, you can't marry your sister or your brother or your children or your parents. They're all within that first degree of that are prohibited. The next one is your prescribed formalities. For instance, yeah, your first one would be like your marriage officer. Is the person who's marrying you allowed to marry you? Because if they are not a marriage officer, then they can't actually marry you, in which case your marriage is void. However, there was a case that they do reference in the prescribed book that say you don't have to have strict compliance with some of the formalities. For instance, if the parties to the marriage are bona fide and they both believe that they've been married by a person who is a marriage officer, the fact that that person isn't a marriage officer doesn't necessarily void the marriage. They can obviously get permission to condone the marriage. But as a general rule, if you miss the formalities, one of the prescribed formalities, it does render that marriage void. I've got a few notes or a few listings for all those ones. So the prescribed formalities that they list in the prescribed book is you need to have a marriage officer who is actually registered. That when you do the ceremony, there has to be a lodging of objections. So this is the cliche one where the minister will say, does anyone object? And they actually are required legally to do that part. So you can't skip over it. And if anyone did have an objection, that would be their time to do it. Both parties need to be present. And I found this one the funniest. It has to be included, or it has to be done inside a building. So you can't do it outside, you can't do it in the open. It had to be inside a building with the doors open. And I actually went and looked this up myself in the act, and it does tell you it's got to be in the building with the doors open. It's quite, it seems, yeah, a holdover from the past. There was a case as well that dealt with this one where there was a marriage in a garden and then the husband tried to annul it, but the court said that there was consensus to marry, they intended to marry. So just because they missed one minor formality didn't render the marriage void at all. So it appears that if you do miss one of the minor formalities, it's not necessarily going to make the marriage void. But if you do get a question asking about the formalities, the major ones are you need to have a registered marriage officer There needs to be a section where a person can object. Both parties need to be present. They can't marry by proxy. So both of them have to be there at the same time, and it needs to be inside a building. So those are the main ones with regards to the prescribed formalities. Does that make sense so far with regards to the formalities of the marriage and what needs to be included? Okay, perfect. Okay, the next one is the void, voidable, and putative marriages. Now, I noticed there are a couple people that were wondering what the difference was between these three different marriages, if you want to call it that, or these three different terms. So a void marriage is a marriage that never came into existence. So generally, this came about due to a defect in one of the requirements. So we were talking about like the formal requirements. Perhaps the person didn't have capacity to act, or something was missing, or the paperwork wasn't necessarily filed correctly, etc. So this would make the marriage void. It doesn't exist in the eyes of the law. So you might say, I'm married, but in the eyes of the law, there is no marriage. It's void. Then you'll get a voidable marriage, which is where the Okay. Sorry, I seem to have a technical glitch there. Okay, so a voidable marriage is where there are grounds present either before the marriage or at the time of the wedding, and which you could ask the court to set aside things. I'm not going to discuss all those now because I do have a section for that. And then the last one is a putative marriage. So a putative marriage is where that one or both parties entered the marriage unaware that there's a defect that makes the marriage void. So in their minds, it is a valid marriage and it stays a valid marriage until that defect is found. But I'll go into more detail with that further down. Let's talk about the void marriages. So a marriage isn't just void because we think it's void or we think that there are things that make it void. In order for a marriage to be void, you actually have to go to the High Court or the regional magistrates court to have them declare the marriage void on grounds of usually either a non-compliance with the material requirements or the formal requirements. There again, was it done in the correct manner? Was there capacity to act? And so on. So until a court declares the marriage void, it is still a valid marriage. With regards to material requirements, your material requirements are, for instance, was one of the parties already married? Was one of the parties below the age of puberty, for instance, or did one of the parties lack that capacity to act, or even are they related to each other? So all those sort of things are what they call material aspects, and any one of those violations would render the marriage voidable. With regards to the formal requirements, as I mentioned, it doesn't necessarily, just because you skipped a step, make the marriage voidable. If it's done out of, for instance, an error or omission or an oversight, these things do happen. That doesn't make the marriage void. You can normally rectify those things. And I think there was a section in the Marriage Act that talks about rectifying that as well. All right, so consequences now of a void marriage. So let's say now we do have this marriage and it's declared void by a court. So the consequences of that is, number one, the marriage is void ab initio, from the beginning. So we therefore have no matrimonial property system that comes into operation. So it doesn't matter, there's no common law or community of property or outer community property. There is no marriage property system that comes into operation. The spouses also aren't able to inherit from each other. So there's no interstates inheriting, and there's also no reciprocal duty of support. And the reason this is because the marriage is void from the beginning. So it's as if it never came into existence. So there is no matrimonial property system. There's no duty to support. There's no divorce. There's no nothing, because it never actually existed from the beginning. So it's actually quite a serious thing to have a void marriage. All that time and everything you put in is all just gone. Your next one is your voidable marriage. So this is the one where there are grounds present that you could go to a court and say, you know what, at the time of the wedding or just before the wedding, ABC, whatever the case is, I'd like to void my marriage. So the difference between a void marriage and a voidable marriage is a void marriage didn't come into existence. There's nothing there. It's didn't exist. Whereas a voidable marriage is a valid marriage until one of the parties asks the court to set it aside because of a particular formal or material defect. So it's up to the parties involved as to whether they want to continue with the marriage or not continue with the marriage. So really it comes down to what do they want to do. But if a defect was there or there was something there that rendered an avoidable marriage, the person could decide, you know what, I now know that, but you know what? I don't really mind. I love this person, ABC, whatever the case might be. Or they might decide, you know what? I didn't know about that. That to me is a problem, and I can't stay married to this person. You could then go and have that marriage declared void. Your grounds for setting aside avoidable marriage. This does come up in quite a few questions that I've seen. The grounds are minority. So, for instance, a minor fails to obtain the necessary consensus. You can have a material mistake such as duress or undue influence. There was one as well called, I'm not sure if I'm going to pronounce this right, but it was called stuprum, or however you pronounce the Latin for that. That was where a man was unaware that the woman was pregnant by another man at the time of the marriage. The other two were, for instance, impotence and sterility. So any one of those are grounds for avoiding a marriage. Now, with regards to the consequences now of a voidable marriage, a voidable marriage has all the legal consequences of a valid marriage until it's set aside by a court of law. So this would be your high court or your regional magistrate's court. If the marriage is not set aside, it remains in force and it's a valid marriage. So during the subsistence of the marriage, it has all the same consequences as any other valid marriage would have. However, if it does get set aside, the decree of annulment is retroactive, meaning that it goes right back to the beginning and voids the marriage. So it's as if the marriage didn't exist. So then it's the same as if we had that void marriage we spoke about earlier. If a voidable marriage does get voided by a party who says, you know what, this isn't working, I was misled, whatever the case is, they can void that one and then it doesn't exist. What is not affected, I made a small note here, this is quite important. With a voidable marriage, third-party interests, meaning people that perhaps you owe money to, your creditors and whatnot, their interests are not affected by the fact that your marriage gets voided. They still have a claim against you for any debts that were incurred during the subsistence of the marriage. With regards to children, it doesn't affect their status. From a legal perspective, the law looks at it as if the children were born of married parents. And then when the marriage gets voided, the law treats it as if the parents got a divorce. So then you'll have the same consequences as if you did a divorce. The children are of married parents, even if the marriage is voided. Before I move on to the putative marriage, which is the last one, are there any questions with regards to the voidable marriage and a void marriage?
Okay, hi guys. Sorry to just jump in. There's a question on the chat group, on the chat box. Can a marriage become voidable because one partner cheated? So I responded, I don't think so, unless it is a stoprum. Maybe you'd like to explain to them about that.
Okay. As far as I'm aware, you're 100% right. Just because a person was unfaithful doesn't void the marriage from what I've seen in the book. Maybe Sean might know, he can let us know as well. But from what I've seen, the only way that you can void the marriage would be via those ones that I listed. So stuprum, that's particular to a person being pregnant. So if they weren't pregnant, then you wouldn't be able to rely on that. So I'd agree with you and say that I don't think you'd be able to void it. Sean, I see you got your hand up. Maybe you can give us some clarity.
Yeah, no, thank you, Darren. Thank you, everyone. Not so much clarity, but I also agree with the point that it's not a material ground for, say, voiding a marriage, infidelity, that is. And I just wanted to interrogate the point on stuprum, because I also agree that it can be a valid ground to, say, void the marriage if it turns out that say the woman had concealed that she had been pregnant by another man, or if the man had impregnated another woman and had concealed that. But I think the term of stapram refers exclusively to, say, having sexual relations with a third party. And in this case, I think the specific term of stuprum does not constitute a valid term for avoiding the marriage, but I'm not sure. Perhaps I could engage on it.
Yeah, no, 100%. It's a very good question, but yeah, I haven't seen anything with regards to material consequences that would allow it to be avoided, because stipram is specifically for if the woman is pregnant. So I would have, in my humble opinion, I would say that infidelity, even if you discovered that it was happening around the time of the wedding, probably wouldn't amount to the level of a material defect as would be required by a court. What would probably happen is that, say, you can get a divorce and the court might say, well, you were married for a month. So you may be able to, yeah. Anyway, now getting off into the weeds with that one, but yes, I'd say that probably not a grounds for voiding a marriage. Right. So the last category for this chapter was the putative marriage. So just to rehash that one, that is a marriage that either one or both parties enter into that they were unaware that there's a defect. So remembering the defect could be something, for instance, consent or something along those lines. Perhaps the person was married and they both thought that they weren't married. Maybe the one partner got a divorce many years ago, or he assumed he got a divorce many years ago and was able to marry. And it turns out that actually, no, they didn't actually legally get divorced. So in this case, the marriage is what they would call putative because both parties or one party believed that the marriage was valid, but from a legal point of view, it wasn't a valid marriage. So they give it its own, I suppose, special category. With regards to the consequences, a putative marriage will continue until that defect becomes aware to the parties involved. So the marriage will be as valid for as long as they are unaware that there is a defect that makes the marriage a void. But the moment they become aware of that defect, that would then void their marriage, and the so-called putative marriage comes to an end. I see your hand, Sean. You got something for us.
Yeah, no, thank you, Darren. I just went into the chat and I looked at the question that we're discussing. And to the extent that we're discussing it, I think we've addressed it, but I just wonder if the person may mean that can, say, cheating be a grounds for divorce. And I would say that, yeah, this would be covered in the session where we discuss divorce and the grounds for divorce. If they were asking if, say, infidelity can be a grounds for divorce, and maybe it might be important for us to differentiate between divorce and making the marriage void, if that confusion might have existed.
Yeah, that's a good point. We will probably end up covering that in the divorce section. The way I understand it is infidelity in itself isn't a grounds for divorce. It's the Divorce Act talks about irreconcilable differences, but then you would argue and say, what, because this person was, they cheated, they did their thing, my trust is now broken. Therefore, because the trust is broken, I can't, live with this person, or I can't see a life with them, etc. Therefore, the relationship has broken down. You would then argue that as a reason for divorce. But perhaps we can cover that a bit more in the divorce section, because there was also a thing in there with regards to infidelity not being grounds for a divorce in itself. But yeah, maybe we can cover that tomorrow night in the divorce section just to keep on track with the marriage tonight. So I'm not sure who was asking the question in the chat. I'll go back and have a look after the session, but maybe tomorrow night you can just pop it on again and remind us, and maybe we can go and see how that fits in with regards to divorce. Sean also raised a good point now. There are certain patrimonial consequences between having a void marriage and having a divorce. So when you have a marriage voided, whether it was a voidable one or a void marriage, when you void that marriage, it's as if the marriage didn't exist, which means there's no a matrimonial property system, there's no reciprocal duty of support, there's none of those things come into existence. Whereas if you go the divorce route, there was that marriage in place, which means we're now talking about divorce and maintenance and all those sorts of things. So from the patrimonial side of things, the money side of things, if you wanted to go this route, you'd want to have the marriage voided, because then you don't have to worry about divorce, you don't have to worry about splitting assets and doing all those sorts of things, because legally the marriage didn't exist. Whereas if you went the divorce route, now you've got to pay maintenance and you've got to sort all these sorts of things out. So your primary goal there would be void the marriage if you can, because the patrimonial consequences are like non-existent. Because when you void the marriage, you get put back in the same position you were prior to being married, whereas divorce doesn't do that. Divorce has its own consequences. So there is a difference between the two, and I think maybe we'll go over that again tomorrow for the divorce and maintenance section, just to highlight those particular things. So there is a difference between, from a money point of view, do you void the marriage or do you get a divorce? So there is that difference. All right. The last part for this putative marriage, it's so the moment one of the parties becomes aware that there's a defect that makes their marriage invalid, that putative marriage then stops. It's void. And putative marriages are void ab initio. So from the beginning, same as a voidable marriage and a void marriage, they never came into existence. So the moment the parties discover that there's this defect, that marriage comes to an end, and it's as if it never existed. It becomes a void marriage. Here again, if there are children that are born during this putative marriage, they are treated as if they were born from married parents. So that point doesn't change. So the children still retain those particular rights. And that's pretty much that chapter done. Are there any questions with regards to a putative marriage before we move on to the next chapter? All right. It looks like we're all good. All right. Hey, we're making some good time tonight. This is awesome. We'll have some time at the end to go through some of those questions. All right. So the next chapter talks about the invariable consequences of a civil marriage. So these are the ones that you cannot change. They are ex lege. They are just part of the whole marriage system, and you can't opt out of them. And I've only made a couple of notes out of this particular section. The most important one being that reciprocal duty of support. So when the marriage comes into existing, from the beginning of the marriage all the way until it's terminated, there is this duty of support that the spouses owe to each other. But for there to be this duty of support, there is some common law requirements, and these are important because I've seen a couple of questions asking what these are. And the three requirements is number one, there needs to be a marriage. There's no reciprocal duty of support unless there is a marriage. The spouse who claims the maintenance must need that maintenance, and then the spouse from who it's claimed must be able to provide it. So if they can't provide it, well, then they can't claim it against the spouse. But those are the three. The first one is there needs to be a marriage. The spouse who claims the maintenance must need it, and the spouse from whom it's claimed must be able to provide it. So those are fairly easy to remember. Perhaps even highlight them if you need to, because I have seen a couple of questions that do ask about those common law requirements for the duty of support. And then when does it terminate? So the common law duty of support terminates upon the dissolution of the marriage. So when the marriage comes to an end, so does that common law duty of support. Now, it's important to note this is the common law duty of support. It's not to do with maintenance, which is the legislative side of things, and we'll cover that tomorrow. But from the common law side of things, when that marriage comes to an end, the duty of support that the spouses give to each other also comes to an end. And what are these duties of support? It can be things, for instance, household expenses, supporting each other in those sort of areas. And even with household expenses, there are three requirements before you can even have or claim household expenses. The first one is there needs to obviously there again be an existence of a valid marriage. There needs to be a joint household, and the transaction needs to relate to the household. So a person can't just say, "Ooh, I'm buying these, I don't know, fancy silk clothes, whatever the case might be, and the other spouse decides to contend that that's not a necessary, that's a luxury, the person will probably get away with it then, because let's face it, it could be a luxury. There were a couple of cases in the prescribed book where they spoke about household necessaries. I haven't specifically mentioned them here because I haven't seen a lot of questions talking on this. But if they do ask about household expenses, the 3 requirements in order to be able to have those is that there needs to be the valid marriage. They need to have that joint household. In other words, they're sharing that home, and it needs to be a necessity for the household. So that's like buying food. It's looking after the children and maintenance and things along those lines. It's for that joint household. The other important thing is both spouses are entitled to live in the matrimonial home. One spouse cannot kick the other spouse out. So even if the one spouse, for instance, is the one who's renting or even owns the building, they can't kick the other spouse out. Both spouses have the right to live in the matrimonial home. You can't kick one or the other out. Last point for this one, and I have to include it, is it's to do with surnames. If you remember from this book and PVL as well, when a person gets married, particularly from a woman's perspective, she can take on the man's surname, or she can keep her name, or she can have a double barrel surname. Prior to, I think it's this month, men weren't able to do that unless they got permission. However, there is that new case that came out. I'm sure it was earlier this month, unless it was in September. It's the Jordan v. Minister of Home Affairs, where the Constitutional Court said that that section of the act was unconstitutional because it allows women to take on the husband's name, but doesn't allow the man to take on the wife's name. So for this particular exam period, I'm assuming that UNISA haven't changed those particular questions, and this will only take effect in the next semester. But it is something to remember that men are also allowed to now take the woman's or take the wife's surname or a double barrel name, and also to revert to any name he had before that. So now it's the same for both men and for women. All right, nice, short, sweet. Does anyone have any questions with regards to the reciprocal duty of support? Yeah, looks like we are all good. Perfect. All right, now we get to the meaty part of this book. The first one we're going to talk about is the marriage in community of property. If you thought divorce was messy, marriage apparently is also very messy. There are so many things going on in this module. All right, so marriage in community of property. So if there's no antenuptial contract, then it's assumed that the marriage will be in community of property. This is actually the default position, and the only way not to have community of property would be if you had an antenuptial contract that specifically said we are not having anything in community of property, we're having separate estates and so on. So in community of property, there is no antenuptial contract. The nature of community of property is that all assets that the spouses own at the time of the marriage all fall into a joint estate. So this means any debts, any assets, any houses, cars, whatever the spouses own, all fall into that joint estate. So it becomes like this communal pool of assets that both of them are entitled to. With regards to transfer of the naming of the assets, the ownership, that automatically happens by operation of the law. When the spouses enter into that marriage, they automatically become co-owners of all assets. So it's not like they have to go and specifically apply for ownership in each and every single asset. By operation of the law, the moment they get married in community of property, they all become co-owners of all the assets and also the debts. So it's a two-way street there. You can't have one without the other. Everything basically gets pooled together. Now, there is an exception where they call it separate assets. So this is where assets are excluded in a separate contract. However, this only as as between the spouses. It's not binding necessarily on third parties. So from the outside looking in, it's one communal pool of assets and liabilities, but the parties themselves can obviously make their own arrangements and they can enforce their own arrangements amongst themselves. So that's sort of like an internal arrangement. So they can make up like a contract that says what will or won't be included. There are some separate asset categories that are listed specifically in the prescribed book are, for instance, engagement gifts. So each person who received engagement gifts, these gifts belong to each other and they're not joint assets for both of them. So like engagement gifts, non-patrimonial damages, so that's for like damages against one's dignity and things like that. Damages with regards to personal injury that the other party inflicted, those would all go into separate assets of the party. So you would have the wife's separate assets and you have the husband's separate assets. So amongst themselves, they do have a slight separation of assets. But it doesn't affect, obviously, third parties because from a legal point of view, all those assets form in one pool. So, which brings us to the recovery of debts. Now, there's two main parts of this, and they're quite important because they operate slightly differently. The first type of debt you have are contractual debts. So, a third party that can recover a debt from the joint estate, even if the spouse didn't have the consent of the other one. So, for instance, there are some things that a spouse cannot do. For instance, I want to buy a house. Well, you can't do that without the other spouse's consent. However, if the person selling the house didn't know about that, the transaction is still valid because they wouldn't have known that there was another consent that wasn't there. With regard to debt, that's where there is damages involved. A delictual debt needs to be claimed in a certain order. So number one is it needs to be claimed from the separate property of the spouse that incurred the delict. So for instance, if the husband goes around and he, I don't know, was drunk at the bar and he punched someone, that person would then obviously have medical bills. Before they could attach the joint assets in the marriage, that person would first have to go to this husband's, what they would call separate assets, if he has any, and claim against those first and foremost. If the husband's separate assets are just not enough, that person can then claim against the joint estate. So in other words, all the assets and the money that's in that same pool, they can then claim against that. So yeah, as I mentioned, this can get really, really messy very, very quickly. But the two main things to remember for the recovery of debts is you get two kinds. It's contractual, aka contracts, and the other one is delictual, which is damages. So with contractual debts, the person has to first go after the person who signed those debts. And even if there isn't consensus from the other party, it doesn't make that debt void. Unless, of course, the third party knew that, hey, your wife is supposed to sign for this. She didn't sign for this, but it's okay. I'll just tell people I didn't know. That wouldn't work because that third party knew that he didn't have the consent. But if the third party didn't know that, then the transaction would still be valid. So it's not like a get out of jail free card. Oh, my wife didn't consent, therefore I don't have to pay back the debt. It doesn't work that way, unfortunately. I'm going to leave some of that out for tomorrow. All right, so what happens now when you start dissolving this joint estate? So we all got married, we're all happy, we all threw all our stuff in together, but things are not working out and you get a divorce. But now how does this work? Because all our assets are sitting in one big communal pool, we're sharing everything. So what will happen is here again, we have a difference between the contractual debts and the delictual debts. So on a contractual debt, any antenuptial debt, so an antenuptial debt is debt that the person brought into the marriage. So it was existing before you got married. Any debt that existed before the marriage that remains unpaid after the marriage can only be recovered against that original person who signed the debt. So if the wife decided I'm buying a whole house full of shoes and then she got married, that debt would then obviously fall into the joint estate, but now they're getting divorced. And after the divorce, what will happen? Because she was the original debtor for those fancy shoes she bought, the third party can only claim the debt against her. They can't go back to the husband. All right, so that's with regards to antenuptial debts. Any debts that incurred during the marriage, they can be claimed either in full from the original spouse who incurred the debts, or half the debt can be claimed against the one spouse, and the other half can be claimed against the other spouse. So those are the two ways that you're going to find contractual debts get divided within a community of property divorce. Then with regards to delictual debts, delictual meaning that there were damages involved to a person. So in terms of common law, only the original debtor can be sued for any delictual debts after the marriage has been dissolved. So if, for instance, we were talking about the husband was at a bar and he punched someone up and now that person is suing the husband. let's say, for instance, the husband hasn't paid, but now the divorce has been dissolved, or the divorce, the marriage has been dissolved by divorce. That person who was injured can't go after the wife and claim, because the delictual debt can only go after the original debtor, which is the husband. So that guy who got beat up in the bar can only claim against the husband. He can't claim against the wife because we're dealing with a delictual debt. So, and there again, the original debtor in this case is the husband. He can't now go back and say, hey, wife, we were married in community of property. We're supposed to share the debt. You can't do that with delictual claims. After the divorce of a married in community of property, the wife does not have to now pay the husband half, and the husband can't claim that one because delictual debts can only be claimed against the original debtor. Does that make sense with regards to the contractual debts and the delictual debts? Right. Okay. Now let's go on to the administration of the joint estate. So there are certain things that a person can. Ah, see a hand coming in under the wire there. All right. What's your question? You just have to unmute your mic and then you can ask your question.
Thank you very much. Mine is on the delictual contract to check if, for instance, like you are highlighting that you are involved in a incident where someone starts to sue you and the proceedings have commenced before the divorce has started, the application was, and then the divorce is finalized before finalize your issues. Does this outstanding bill continue to remain with you, or is it sorted in the proceedings of the divorce?
Okay, you were asking about the delictual debt. So the delictual debt, if the divorce gets finalized before that debt is paid, then only the person who originally contracted the delictual debt has to pay. So it doesn't become a 50-50 between that person and the other spouse. That person takes that debt with them out or post divorce.
And then if the application for divorce commenced after the person went after your estate, does it still remain the same?
So you said that they came for you after the divorce.
Apologies. I think my line is not so good. It was two facts on what I've raised earlier on, to say the commencement of the this them coming after your estate. They have commenced before the application for divorce has commenced. Will they split the amount, or does it still remain with me as the original founder of this debt? Can colleagues hear me?
All right. I can hear you there. You're quite soft, but from what I'm understanding, you're asking if there's still a debt that's left over after the divorce has been finalized, but was started before the divorce was finalized. So my understanding on that would be that any debt that's still outstanding by the divorce would then be the responsibility of the original debtor. So for instance, let's say that, and using the example where the husband had beat up someone in the bar, and let's say they only paid half the medical fees by the time they got divorced. Well, the balance has still got to be paid, but that half would then still come, or whatever the balance was that was left after those medical fees would still come from the husband, because he was the original debtor for that delictual debt. So if there's anything left over, whoever was the original, let's call it the target of that debt, would then still be responsible for that debt. But I see Sean's got his hand up. Maybe he can explain it a little bit better than perhaps I'm explaining it.
Yeah, no, thank you, Darren. I think the first part, you've addressed the first part of the question very well, but I'm not sure if I heard there was a second scenario to the previous speaker's question, and they mentioned a scenario wherein, say, this person goes and beats up someone at the bar, but they're still married, and then say these suits for damages ensue. What happens in that case? Say 6 months down the line, they start a divorce. Will those damages be part of the joint estate as to be addressed in the divorce, or will they also stay with the party who initially incurred that liability?
All right. So the way I understand it is, if this was all started while they were still married, and that would obviously become something that the estate has to pay, because they're obviously jointly liable, because perhaps the husband doesn't have enough separate assets to pay for it. If he doesn't have enough separate assets, then the joint estate is going to be liable for that. But let's say, for instance, it was done on a payment plan, and you had to pay X amount every month, and this all happened before they got divorced. So they've been paying every month now from perhaps the joint estate or whatever the case might be. But now they've got divorced and they've only paid a third of those damages. So now, after that divorce, what will happen is the wife can claim for an adjustment, because he incurred that delictual debt, and she will say, but we've paid X amount from our joint estate for this, therefore I need to be compensated. And then what will happen is the court will then compensate his assets towards her to make up for the fact that he incurred the debt, and whatever's left over after that, he is still going to have to pay himself, not the wife. I'm not sure if I'm explaining this very well, but whatever happens after the divorce, even if it incurred before the divorce, the person who originally contracted that delictual charge is the one who still has to pay it, regardless of how much is left. And whatever was paid during the subsistence of the marriage, the wife can actually claim that back when they get divorced. And she can say, you know what, it's not 50-50 anymore. I need to get 60% of the estate, because we use joint money to pay for his delictual debt. So during that divorce, they will also do an adjustment for the wife, and then whatever's still left to be paid, the husband is still going to have to be paying for that, assuming, that same scenario for that delictual debt. But yeah, hopefully I'm explaining that a bit better. All right, I see we have another hand up. Sure, I'm not going to be able to pronounce your name with justice. No, I'm not going to do that for you.
Yeah. Okay. Good evening. I just wanted to add something with regard to the joint estate. I'm not sure if I'm visible. Can you hear me?
Yes, we can hear you.
Oh yeah, with regard to joint estate, usually maybe when the divorce process starts, both parties will come up. Maybe I will say I will pay for my own debts, or you will have to share them. So it will only depend on the parties as to what is it that they are agreeing upon. Because some of the debts we will find out that we took them together. But now that we are divorcing, the debt is under my name, but we can reach an agreement that whatever money that we are going to add, we are going to settle half of the debt that we are having. So I think on that one, it only depends on they call it a divorce settlement, where parties discuss as to how are they going to go about their divorce so that it can be finalized.
Yep, no, 100% you're spot on there. If there is a divorce settlement, then that would obviously then determine who pays for what. But if it had to come down where no party wanted to do a divorce settlement and the court had to make a ruling, normally contractual debts would then be split 50-50, depending on who it was that incurred it. But I think you are right. I think most times people would prefer to go for a settlement, because then we all know exactly what we are paying. All right. All right. Are there any other questions with regards to that?
Hi, yes, there's a question.
Yes.
My question is, if, let's say, according to your example, the husband beats up a person at the bar, if it happens before the husband marries the wife, can stand claim against the joint estate, or the person is just gonna claim against the husband?
Sorry, I didn't hear that last part. You said that this happened before the marriage, and then you said they got married, and I didn't hear that last part after that.
If they get married after the incident happens, can the person whom the incident happened to claim against the joint estate, or the person is just gonna claim against the husband?
Okay. All right. So what happens with delictual claims is that you've got to first claim against that spouse's separate assets. So he'll have a bank account, he'll have things under his own name. So that person who was beat up in that scenario would lay a claim first against the spouse's separate assets. So everything in his particular name. If, for instance, there wasn't enough money in his bank account or his assets, whatever the case is, in his own separate assets, whatever the balance was would be taken out of the joint estate. So they first go after the person that caused that delictual damage, and only if there isn't enough asset value there or money there to settle the claim will it then go to the joint estate.
Okay, thank you.
Awesome. Right. Okay, I think I'm going to skip this section with regards to the administration of the joint estate just purely because of time. I want to get to the section on a marriage out of community of property. But very briefly, the administration of the estate talks about when do you need consent from the other spouse. Yeah, I think maybe you can just look this up in the book yourself. It is fairly straightforward, so I don't think I will spend time reading over that. But it's purely just to do with do you need your spouse's consent to buy a house or to pull money out of your bank account or things along those lines. It is important to read that section because there are a number of questions that will ask you about consent from the spouse with regards to different transactions that happen. But I think just for tonight, let's move on to marriage out of community of property. So this form of marriage is different to the community of property. Here, each person's estate is kept separate. So there is no joint estate like you would get in a community of property. In order to enter this form of marriage, you need to have an anti-nuptial contract, which will specifically say that you are marrying out of community of property. There are a number of formal requirements that you need. The first one being that the contract needs to be executed before a notary and then has to be registered in the deeds office. So this is very, very important because it's only valid if it's executed by a notary and it's registered at the deeds registry. If we don't do that, then we don't have an anti-nuptial contract. So it's very important to do that. And then the time frames for that is you've got 3 months from the moment you execute the contract to register it with the deeds office. So you've got to make sure that it's done by a notary and it's registered within 3 months. Otherwise, you don't have a anti-nuptial contract. There are times where you can do what they call a post-nuptial registration, but you've got to get the court's permission, and there are certain requirements that you've got to meet. So, for instance, let's say that there was a formal requirement that was defective and maybe you didn't do it within 3 months or something along those lines. You now have already been married and you've just found out that, oh, my anti-nuptial contract wasn't even registered. So we now have to go to the courts and we've got to tell them, hey, look what happened. It wasn't our fault, A, B, C, and all the rest of that. The court then has 3 requirements. So they'll say that, for instance, that you need to have a agreed on these terms of the anti-nuptial contract before you entered in the marriage. You must have a good reason for why you failed to execute it. So, for instance, we thought we executed it. We gave it to the lawyer, but the lawyer took too long. By the time he remembered, it was 4 months in, and therefore it's not our fault. So that would be like, for instance, an example of a reason as to why it wasn't done. And then the last one is that the application has to be made within a reasonable time that you discovered that your anti-nuptial contract wasn't actually executed or registered. So those are the 3 things you need. So number 1 is there needs to be an agreement that you entered into an anti-nuptial contract. So you both need to agree that that's what you did. You need to have a good reason as to why it wasn't done. And third, you need to do it within a reasonable period of time. Now, they don't say what a reasonable period of time is, but I'm assuming, you know, you found it out and then you rectified it as soon as you possibly could. With regards to what can be in an anti-nuptial contract, generally you can include any provision that you want, as long as it's not impossible. It's not against what they call contra bonus mores, which is against the good morals of the society, or contrary to, for instance, the Constitution or any other law. So as long as you're not doing something shady, you can pretty much put almost anything in your anti-nuptial contract. What you can't include, for instance, is I'm going to put a clause in that says we have to remain faithful to each other. They won't allow that. Or, for instance, we need to live together. That would also be a void clause. Other clauses that you couldn't include would be, for instance, a clause that waives your right to maintenance. So if we ever did get divorced, neither one can claim maintenance. You wouldn't be allowed to put that in. Same goes, for instance, any clause that would encourage separation or divorce. So anything along those sort of lines would be a void clause and would not be enforceable. And as I was saying earlier, in your anti-nuptial contract, there needs to be a section that specifically mentions what your matrimonial property system will be. So it needs to specifically state that we are not in community of property, we are out of community of property. So it's very plain and expressly written down that we are not in community of property. Other things that you can also include in your anti-nuptial contract, and this is discussed quite heavily in the book there, so I'm just going to briefly mention it, is a succession. So you can include what they call a pactum successorium in your contract, which is basically a big fancy word to say, what do we do if one of us dies? Now, normally you can't do these sorts of things. If you're doing PVL2601, you would have read in there that, you know, living people can't make these sorts of arrangements between each other. It's not allowed. But in this particular case, it is allowed for anti-nuptial contracts. So, for instance, a person could say that, you know what, the surviving spouse out of the first one of us, so if one of us dies, the surviving spouse becomes the sole heir of our estate. Or they might put in there that on the first spouse dying, our entire estate will devolve to our children. So you are allowed to put some of those things in an anti-nuptial contract. You can also put in, for instance, marriage settlements. You know, so I agree when we get married to give you the beach house to use for as long as you want, or whatever the case may be. So you are allowed to put all sorts of things like that in your anti-nuptial contract. With regards to interpreting a contract or your anti-nuptial contract, let's say there is a dispute. You don't know, I thought this way, you thought that way. Now we have a disagreement over how it's to be interpreted. An anti-nuptial contract is treated and interpreted the same as any other contract. So there's nothing particularly special about it. So you'd follow the same rules for contract law. With regards to amending your anti-nuptial contract, you can only really amend it or cancel it up until the point that you get married. Thereafter, it's not really possible to change too much because there's a immutable property or law with regards to marriages. You can't change the marriage system once it's been enacted. So, I mean, yeah, so the anti-nuptial contract allows you to do quite a lot of things. Just remember that some of the things that you can't do are, for instance, telling people they need to remain faithful, waiving maintenance, or anything that encourages separation or divorce. I think I remember seeing a question in the mock exam along those sorts of lines. All right, with regards to the types of out of community property marriages, there are three main types, of which you only really use two in modern South Africa. But all three are, number one is the complete separation of property. Or if you want to get very fancy, it's quite a mouthful in the book. It's marriage out of community of property and out of profit and loss without the accrual system. It's quite a mouthful. I've just abbreviated it to complete separation of property like they do in the prescribed book, and it's a lot easier to remember. I believe they don't do a lot of that anymore in South Africa, and there are question marks with regards to the fact that there's no accrual. But that's the first one, complete separation of property. Your second one is marriage out of community of property with the retention of profit and loss. So this is where your profit and loss are shared, and the sharing happens during the course of the marriage. The last one is the marriage out of community of property and with the accrual. Now, this one also has profit sharing, but only profit sharing. There's no loss sharing. It's only the profit sharing, and the sharing only happens on the dissolution of the marriage. So when the marriage comes to an end is when we share it. So if you're like me and you're wondering, what's the difference between marriage out of community of property with retention of profits versus marriage of community of property with accrual? What's the difference? I was also confused at one stage. And the main difference comes down between those two systems is the first one, which is the marriage out of community of property with the retention of profit and loss. The sharing happens during the course of the marriage. So it's a continuous sharing of the profit and the loss. Whereas the marriage out of community of profit with the accrual, you only share the profit, and it's only shared when the marriage comes to an end. So that would be like when there's a divorce or when there is a death that ends the marriage. Only then do you share the accrual. So that's the main difference between those two systems. One shares during the course of the marriage. The other one only shares when the marriage comes to an end. I see a lot of people also asking about the accrual. So the accrual is how much each estate has increased in value since the beginning of the marriage. And the accrual is put in to try and make the marriage more fair with regards to when it comes to the divorce, because perhaps one person is a stay-at-home parent and the other one is out working. So the one person's estate will obviously improve quite drastically compared to the other. So on divorce now, when you have the accrual, you'll take that difference in value and you'll share it 50-50 between the two spouses. So for instance, let's say spouse A started off with 100,000 Rand and spouse B started with 0 Rand. A went from 100,000 to 200,000 and B only went from 0 to 50,000. So what we do now is they're getting divorced. What is the accrual value? So what we've got, A ended with 200 but started with 100. So that's 100,000 increase that spouse A has made. Spouse B started off with nothing, it was 0, and went to 50. So they've made a gain of 50 over the course of the marriage. So if we take the 100 from A and we minus the 50 from B, we're left with 50,000. So the net accrual between the two estates is the 50,000, and then we split it 50-50. So each spouse would then get their 25,000. There are a couple of calculations that are formed on the mock exam for that one. I don't see too many, but it would be good to be familiar with how to calculate it, specifically what is not included as part of the accrual. I think there are more questions with regards to what isn't included in the accrual than specifically calculating the accrual. So with regards of what is not included in the accrual, any asset that's part of the antenuptial contract is not part of the accrual. So when you got married, you signed an antenuptial contract that said, these are my assets, those are your assets, and we're keeping them separate, etc., etc. So anything that's in the antenuptial contract doesn't form part of the accrual. Any donation that a person received is not part of the calculation. Any inheritance or legacy that they receive is also not part of it. And any non-patrimonial damages. So those are damages not related to what would we call it, physical loss on assets and that. So that's, for instance, someone insulted you and you took them to court and you won your case of defamation against them. None of those sources of money would be part of the accrual. So this is important. So it is assets that are excluded in the antenuptial contract. It's donations, it's inheritance and legacies, and non-patrimonial damages. Neither of these are part of the accrual calculation. And if you guys have been doing the mock exam on the site, I'm sure that you would have seen there's a couple of questions where they say, right, there was a donation of 100,000, there was a 200,000 Rand legacy, etc., etc. And I'll then ask you what values make up the accrual. And now you've got to remember, well, donations don't count, inheritance and legacies don't count, etc. Whereas loss of income, for instance, if you had loss of income protection, you were paid out, that would form part of the accrual because it doesn't fall into these excluded categories. So for those that are taking notes, I'll list them again because it is important to remember. The categories are assets that are excluded in the antenuptial contract, any donation, any inheritance or legacy, and any non-patrimonial damages. None of that forms part of the accrual. And then with regards to the accrual, it doesn't actually relate to a particular asset. It's more to do with monetary amounts. So when you dissolve the marriage, it's not like saying, well, you know, the house is this and you get the car, and it's to do with the value. So what they'll do is they'll put a value on the house and the car, on all the different assets that form part of the accrual. There'll be a value placed on them. And what they'll do then is work out the value that you have to pay the other person, because sometimes there'll be one person's name on it. So the one person might have the car, the other person might have the house, and they'll work out what the values of all these things are. And the person who has that higher accrual value will then pay a monetary value over to the other person. Now, the caveat with all of this is, as the other person mentioned, you can do marriage settlements, but I haven't specifically spoken about them tonight because we're going to cover that tomorrow under divorce and maintenance. But all of these things are the general ideas of what would happen. But if a person entered in a marriage settlement where they said, you know what, I'll give you this, you give me that, and you agree amongst yourselves how you want to divide the property, that's perfectly acceptable as well. But I haven't mentioned that tonight because that will be tomorrow's nights with the divorce and maintenance. All right, before we jump into a couple of questions that I screenshotted off the mock exam, does anyone have any questions with regards to the marriage out of community of property? I'm not seeing any hands up. Cool. So you guys want to jump on? I've got about a couple of questions. Here you guys are coming in under the wire. Then we have to start that auction mode again. All right, Juliet, go for it.
Yes, I would like to ask if people they are married out of community of property, and then it happened that the other spouse is sequestrated. In terms of sequestration order, are they going to join their estate, or is it going to be a separate estate in terms of sequestration? Thank you.
Good question. So they will have, it'll be completely separate. If one spouse gets sequestered, it doesn't affect the other spouse because legally there are two separate estates. So in community of property, because everything gets joined together, if one spouse gets sequestered, they both get sequestered. When it comes to marriage out of community property, because legally it's two different estates, when one person goes insolvent, it doesn't affect the other person at all.
Thank you so much.
Perfect. Okay, we've got one more hand up. Just unmute your mic and you can ask your question.
Thank you very much, Darren. Yes, mine is more of a concern which seeks to speak to antenuptial contract as a standalone item. This is a contract which you sign with a not conveyance, I said not commercial.
A notary.
Yes, but notary, yes, notary. And then the notary is the one who takes you through, agrees with you what needs to be included and what is not in line with the Constitution and the Bill of Rights. And then you sign, you are under the impression that this is how you are covered, only to realize later when you're not there to say, but what you agreed on was not in line to Bona Morris, like you were saying earlier on. So my concern is the notary, which is the one who's assisting us to formulate the ideal antenuptial contract, which we strongly believe that has covered us in accordance to our agreement. When this thing becomes nullified somewhere in the future, is there any form of accountability that is taken by the notary?
I would imagine if it's quite a serious breach of your trust in them and their experience, you would be able to report them to the Legal Practice Act, I would imagine, or the council, because they obviously oversee attorneys. So if that
Correct.
person was really bad with their advice that they gave you, but obviously now there's going to be a spectrum on this. It's going to have to be pretty bad for them to obviously investigate. So we're assuming it's not just a minor error, but if you specifically told them something and they gave you really bad advice, your only recourse, I would imagine, would be to report them to the council and have the council investigate them. And then obviously if the council does find that there was a problem, they can sanction them. Unfortunately, I'm not sure how that will help you, though, with regards to the antenuptial contract. You could perhaps then go to the court and say, you know what, this person did ABC, advised us wrong, and we'd like to do an adjustment. There was a case in the prescribed book that does talk about this, where a couple got married in community of property, but then they wanted to start a business and then found out that community of property is not the best thing if you want to go into business, and the court did allow them to change it. So I would imagine in this particular scenario, after you've reported the attorney or the note, whatever the case might be, you could then approach the court and say that, you know what, when we entered this thing, we were advised badly because they didn't really help, or whatever the case might be. And this is what we want to do. Can we change? And if your reasons are good enough, the court may allow you to then rectify or amend or change your antenuptial contract. But obviously, this would depend on quite a few variables and whatnot. But that's pretty much my viewpoint on how I think it would be.
Thank you.
All right. Any last questions before we do the mock quiz questions? We'll have to do the whole auctioneer thing, like going once, going twice, 2 3/4, 2 4/5. Perfect. We can move on to a couple of questions. All right, so that's pretty much the main part of all the notes that I've covered for tonight. So if you do need to carry on with your evening, you are welcome to leave us. I'll see you on the WhatsApp group. Otherwise, if you are able to stay around, I'm going to pull up a few screenshots that I took of questions, and we can maybe just work through a couple of them until maybe, I don't know, about 8:30 or so, maybe 20 to 9, and then call it a night. So are you guys up for a couple of questions? Okay. Let me just share a window with the questions. All right, so hopefully this works. I've loaded up a screenshot. You can maybe give me a thumbs up when it pops up on your side. Perfect. I see a thumb going up. All right, so what I'm going to do is I'm just going to read the question out for those that perhaps can't see it or they're only listening in on audio mode. But our first question tonight says that a wife who is married in community of property does not need the consent of her husband to institute or defend legal proceedings relating to, and now we've got 4 options. So the first option is patrimonial damages for a delict she committed against a third party. The second option is patrimonial damages for a delict a third party committed against her. Third option is non-patrimonial damages for a delict a third party committed against her. And lastly, non-patrimonial damages for a delict she committed against a third party. So who wants to take their first stab at this question? And you know, which answer do you think is the correct answer for this question? So we need to know which one doesn't a person need consent for if they're married in community of property. All right, otherwise I'll give you the first one. We'll get the ball rolling on this one if there's no brave people for this first question. Okay, so let's see. What are our options? Does not need. Aha. Okay, so I would say that the answer here would be option B, patrimonial damages for a delict a third party committed against her. If I remember correctly, any non-patrimonial damages are able to be done without the consent of the other spouse. So option B should be the, oops, sorry, not option B, it should be non-patrimonial damages. So it's actually C, non-patrimonial damages for a delict a third party committed against her. Sorry, option C, not B, because it's got to be non-patrimonial. Anything that's patrimonial does require the consent of the other spouse with regards to community of property. Right. Oh, so we're done with this question. Anybody have any comments? Oh yeah, there we go. Hand, Juliet, go for it.
Yes. With regard to the option B, does it means that the wife can pursue to institute the legal proceeding independently, right?
That's correct, but option C is the correct option because it's got to be non-patrimonial damages.
Oh, you said C. Oh, I thought you said E. Oh,
I
you
did
said
say
C.
B originally because I misread it. I was just reading, oh, that's the correct answer, but it's got to be a non-patrimonial damages. So option C is the correct one. If it's non-patrimonial, the spouse is able to pursue the recovery of those damages, but it's got to be non-patrimonial and it's got to be committed against the spouse. It can't be something the spouse committed. So that's why option D wouldn't be correct, because option D is something that she committed. She wouldn't be allowed to do that without consent. So option C is the correct one. It's non-patrimonial damages for a delict a third party committed against her. So it's got to be non-patrimonial.
All right. Thank you so much.
Right, here's our next question. If you are using your phone, you can pinch the screen and you can zoom in and zoom out, because I know sometimes the writing is a little bit small when you share your screen, or depending how the picture is. So if you need to zoom in, you can just pinch your screen and zoom in. All right, so this question says that Sela and Puleng, I hope I'm pronouncing that right, Puleng, are parties to a civil marriage. They want to embrace their cultural heritage and convert their civil marriage into a customary marriage. Is such a conversion possible? So our options are, number one, yes, the Recognition of Customary Marriages Act allows parties in a civil marriage to convert their marriage into a customary marriage. The second option is yes, in terms of customary law, their marriages will be automatically converted when they enter into a customary marriage. Option 3 is no, the Recognition of Customary Marriages Act only allows parties in a customary marriage to convert their marriage into a civil marriage. Option 4 is no. In terms of the customary law, a civil marriage cannot be converted into a customary marriage. Take a moment, you can read over it, and then you can let me know what you think the answer might be.
Give me 0, ma'am. I'm joking. I think
0. Yo, you had me
I
going.
think
I
it's
think 0.
yeah, no, I think it's C, and I think Akani in the chat also said C, and Chireledzo as well. Deborah had also said C to the previous question. I'm only seeing this now in the chat.
Oh. Oh, hey, we got some sharp eagle eyes out there. So we've got one for A, and most seem to be for C.
Yeah, Paul for C as well. Deborah would C as well. So C is winning. Mokhaeti
Yeah.
says A. Someone says A. A seems to be catching on.
Oh, A is catching up now, eh?
Yeah, it's Juliet.
I also
Martha.
say A.
I'll go for A.
All right. Sean, do you want to give them the answer?
I'm just taking a.
Are you taking the polls?
Yeah, but also with, my own angle at it. I'm just thinking C because. Wait a minute. Wait. Please revert to someone else. I need to think carefully about this.
Right. So can I give you guys the answer, or do you want to try for a bit longer and double check your answers, double down on an answer?
Please give us the answer.
I doubled down on
Oh,
C.
oh, you're doubling down. Okay, cool. All right. Those who said C, they are correct. So the key thing in this question is it's a civil marriage that they've got. So if you've got a customary marriage, you can convert a customary marriage into a civil marriage, but you can't convert a civil marriage into a customary marriage. So the correct answer in this one is C. Hey, at least you guys are getting into the hang of this.
Oh no, that's so tricky, man. Wow.
Right, there's our next one. Okay, so this one says we've got to choose the incorrect statement regarding capacity to incur debts for household necessities. So now, key thing here is it says incorrect. So we've got 4 statements, of which 3 are obviously right and 1 is wrong. So the first statement is a spouse's capacity to purchase household necessities is dependent on the existence of a valid civil marriage. The second one is a spouse's capacity to purchase household necessities is dependent on the variable consequences of a civil marriage. The third option is a spouse's capacity to conclude contracts for household necessities is dependent on the existence of a joint household. And lastly, a spouse's capacity to purchase household necessities is dependent on the commodities being household necessaries. Necessaries? Yeah. All right, guys. Which one do you think is the incorrect one? So we've got 3 right ones and 1 wrong statement. So which one do we think is the wrong statement? Remember, if this is an actual exam, tick off the ones that you know are definitely right. Tick those ones off. And then when you've narrowed it down to the 1 or 2 that you think might be right, you can then focus on those ones and the wording for that statement to try and see which one is more correct than another.
He looks suspicious.
Yep, we've got a hand. Which one do you think it is?
I think it's B, and I don't think you guys are going to be able to convince me otherwise. I stand with my answer. Thank you. Bye.
Very confident. I like it. All right, so the correct answer in this one, going once, going twice.
D is suspicious.
He is suspicious.
Very suspicious.
Well, B is suspicious because...
No, D.
Yeah, B.
Well, I'm saying my answer would be D.
Oh, D. I thought you said B.
No,
Not
D.
B. Oh, almost close, but no cigar, unfortunately. So the correct one in this one is, or the incorrect statement, I should say, is the option B, because it says the variable consequences of a civil marriage. So there needs to be a valid civil marriage. There needs to be a joint household. And the last one is the household. It needs to be necessaries for the household. So those are the 3 correct statements. And then the incorrect statement is number B, because it says variable consequences of a civil marriage. So it was a sneaky one, that one. You've got to like take a double tap, because some of them are looking very suspicious there. Especially number D, it's like they threw the words in their commodities being household, and then you start thinking, very sneaky. But in this case, it is option B that's the incorrect one, because they call it the variable consequences of a civil marriage.
And I can see why that other speaker could not be convinced otherwise.
But hey, she got it spot on, so we're going to give her a gold star. Let's see if I can make this.
Thank you.
100%.
Okay, so if a person who has been placed under curatorship because he or she is unable to manage his or her own affairs enters into a civil marriage without the curator's consent, the marriage is option 1, valid and unchallengeable. Option 2, voidable at the instance of the person who has been placed under curatorship. Option 3, voidable at the instance of the curator. Option 4, void ab initio. Now, this one we actually did right at the beginning of the session, so I'm not sure how many will be able to remember that far back. But who maybe wants to... there's a hand up already. What do you think it is?
I'm going to go with option A, but I stand to be confident, so I'm not as confident in this one.
We'll measure it in confidence levels for the number of stars we get. So a void ab initio means that it was void from the beginning, and void means it never came into existence, and voidable means that it's valid but can be, at the discretion of the parties involved, voided. So they love throwing these words around. Now remember, if this is an exam, if you know 1 or 2 that you know are definitely not the right answer. You take them out, and when you're left with the last one or two, you can then try and see which one sounds like the correct answer.
And A is winning in the chat as well.
Oh, A is winning in the chat. Okay. Well, going once, going twice. The answer is definitely A. All the teams in A, you guys get a gold star. So a marriage that's done under a curator or a person who has a curator is valid and unchallengeable because curatorship doesn't affect a person's capacity to get married. So all those in team A or in the A camp, you guys get yourselves a cool gold star. Ooh, this one looks... Ooh, this one's more complicated. Okay, so Sandili claims she entered into a customary marriage with Funani on the 20th of June 2020. She now wants to sue Funani, I hope I'm pronouncing that right, for divorce. Sandili produces a registration certificate as proof of her marriage to Funani. She registered their customary marriage on her own on the 2nd of May 2022 at the Department of Home Affairs. However, Funani denies that Sandili is married to him in terms of customary law and therefore claims that she cannot sue him for divorce. Which one of the following statements is correct? A. Sandili can proceed with the divorce as the marriage certificate is absolute proof of her marriage to Funani. Funani cannot deny the existence of their customary marriage. Option B. Funani can deny the validity of the certificate, but will have to produce proof that they did not conclude a valid customary marriage as the marriage certificate is only prima facie proof of their marriage. Option 3. Sandili cannot register their marriage on her own and the certificate is invalid. She can still sue Funani for divorce, but will have to provide other proof that she is married. Option 4. Sandili cannot register their customary marriage on her own and the certificate is invalid. She cannot sue for divorce. Now, I know we didn't do customary marriages tonight, but, and we have a hand. How confident are you this time?
I'd say 60%, 75% confident about it. I'm going to go with option B because of having to provide the proof, prima facie, of the invalidity of the marriage.
Okay. Awesome. How's things looking over in the chat, Sean? Do we have any takers there?
Yeah, B is winning with 4 now to 1C.
Hey, those are some good odds, eh?
Yeah.
All right. So last chance, you can sneak your little options in there before we're going. 1, 2, and sold. The correct answer in this case is B because of that prima facie evidence. Because a certificate is only proof that it did happen, but it's not absolute proof. So everyone in Camp B, you guys get yourselves a gold star. You must keep track, so you can let us know at the end who got the most number of gold stars. It's like a running competition at the moment. We should actually maybe have like a semester winner. Who gets the most gold stars for the semester? Okay. Right, so this one is a little bit more complex because it involved that other case that I mentioned earlier. So what we'll do for this one is give me the current law as it stands now, not necessarily the law as it was. If you're not sure and you only know the law as it is in the prescribed book, that's perfectly fine. We'll take it. But if you do know the current status of this law, that will give you like 2 gold stars. All right, so we have to select the correct statements regarding the right of a spouse to use each other's family name from the list below. So we've got 4 options. The first one is a wife may assume her husband's surname, but she's free to revert to her maiden name while still married. Option 2, a wife who has assumed her husband's surname but wants to revert to her maiden surname must first bring an application to the Director General of the Department of Home Affairs for permission. Option 3 is a husband may freely assume the surname of his wife and attach it to his surname to create a double barrel surname. Option 4 is a husband who wants to assume his wife's surname must first bring an application to the Director General of the Department of Home Affairs for permission to do so. And we have 4 possible answers. From that list, which one do you think is the correct option? Sure. Hey, back again. Are you going for the 1 star? You're kind of sure, 65%, or are you going for the 2 stars? I'm totally sure. Can't deny me. Can't change my mind.
I'm not sure what stars I'm going for, but then the first option and the last option, I'm just gonna go with those.
All right. Yep, not bad. So first and last, that is option C. Okay. So we've got 1 for C so far. Do we have any A, Bs, or Ds in the team?
I mean,
got-
if we, yeah,
Sorry, Sean, you can carry on.
yeah, considering what you said earlier, given the book versus the law as it is, I wonder if we are willing to consider the Jordan case.
Wait. If you guys are considering the Jordan case, then I'm gonna go with option the first answer being correct, and where is it? The third option and the last option.
All right. Interesting. Okay, so guys,
That's
for the
according
answers,
to this current law.
yes. So for answers, I'll
Okay.
accept either the law as it is in the prescribed book, which is now outdated, or the way the law currently stands with that constitutional case that happened earlier this month. I'll accept either one of those options. So it's up to you to decide which one you want to try and go for, or you can go for both. Hey, maybe make that 3 stars. All right, so the way it stands in the book at the moment, that would be option C, because the first statement and the last statement are correct as it stands in the prescribed book at the moment. However, the law has changed since then. The new status now is both are exactly the same. So as the law stands at the moment, it would be a statement 1 and statement 3 would be your correct options. And the other lady, she said both options for this, so she get like 2 gold stars now. How many got it right in the chat, Sean?
I think my mic was stuck, but I think Martha got it right in the chat. Unless this was a response to the previous question. I am better.
We'll have to give her the benefit of the doubt and give her the gold star. Eh?
Yeah, but yeah, there are some other people who got it right as well. Kamogelo, Marupeng, Millicent.
Sure. Hey, you
And
guys
then,
are on board.
Yeah, Ulfa said maybe A.
Okay. Well, A is correct as the law stands at the moment, because both the husband and the wife are able to take either one's name, make a double barrel name, and or revert back to any other name they previously had. So that is correct for the way the law currently stands with the Jordan v. Minister of Home Affairs case. So yeah, hey, you guys are like getting on a roll here, man. Oh, this is such a small question now. Let's see. Where one of the spouses has been forced to consent to a civil marriage, such a marriage is option A, putative. Option B, void. Option C, valid. Option D, voidable. And we've already got our first hand up. Go for it. What do you think the answer is?
I'm gonna go with voidable, option D.
Okay. Who else? You guys are allowed to chat if you want. You just have to unmute your mic. So if you're feeling brave and you don't just want to type, you are allowed to unmute your mic and chat with us. There we go. In Malopi.
Can I just ask a question, please? Just to clarify the difference between void and voidable, because I feel like I get confused with the two all the time.
Okay, so a void marriage is a marriage that never existed to start off with. So there was never a marriage. A voidable marriage is a valid marriage, but there was a problem or a defect either with the requirements or the material part of it. There was something in there that gives the spouses the option of just saying, you know what, I want to void the marriage. So a voidable marriage is a valid marriage unless one of the parties, one of the spouses decides that this, because of a mistake, because of something that happened, or because of something I didn't know, there was requirement, etc. I don't want to be involved in the marriage anymore. You can then void the marriage. So a void marriage is a marriage that never ever happened. In the eyes of the law, it just never existed. Whereas a voidable marriage is a valid marriage until the parties decide that due to that defect, we no longer want the marriage. I'm not sure if I'm explaining it very well.
Okay, that's clear. Thank you.
All right, so we've got one person so far for avoidable. Anybody else want to take a try at it before I give you the answer for this particular question?
Voidable also seems to be leading in the chat, but there is, what is it, two brave colleagues who say it is void.
Okay. All right. Last chance to sneak your answers in there because the answer is voidable. Okay, so the reason we say that it's voidable is under the list of how would I call it? Options listed for avoidable marriage. One of them is where there's been undue influence. So when a person's been forced to consent, they are able to themselves decide, you know what, I like this marriage, I'm going to stick with it. Or they can decide, you know what, I was forced into this, I don't want anything to do with it. They can then void that marriage. So that was one of the things listed under a voidable marriage. It was duress, it was mistake, it was infertility, stuprum, etc. So those marriages are valid. But because there was a defect, in this case, the person was forced, that defect allows them the option of deciding, do they or don't they want this marriage to be valid? If they decide they don't want this marriage, the marriage is then voidable. And because it never existed, or they might say, you know what, I didn't like it at first, but for whatever reason, I like it now. They can then choose to stay in the marriage, in which case it carries on being a legally valid marriage. We didn't do much of that one. Ah, there we go. We did that one tonight. Okay, so in terms of section 21(1) of the Matrimonial Property Act, spouses may jointly apply to court for leave to change the matrimonial property system applicable to their marriage. One of three requirements to be met before the court approves the application is, now it's giving us four options. Option A, all creditors' claims must have been settled. Option B, there is an equitable distribution of the spouse's property. Option C is the creditors must consent to the proposed change. Or option D, no other person will be prejudiced by the proposed change. And we actually had someone who was asking about how to do this. Can you do this? And there were three things that were mentioned. So, yep, hey, we got a hand up, shop. Go for it. Which option do you think is the correct option?
I will go for option D, that no other person will be prejudiced by the proposed change.
Cool. Kundai? I have to ask again. Am I pronouncing your name right there?
Yes, that's right, Kundai.
Perfect. Okay, so how confident are you with your new answer?
I agree with the first answer that we just received now, so I'm pretty confident now.
Okay, so we've got two options for D. Libahang?
I'm also going for D.
Okay, D.
Yes,
How's
D
it
is the
looking in the
perfect.
chat there, Sean?
Sorry?
Yeah, D seems to be uncontested this time.
Sure, okay. Hey, well then everyone gets the star then, because D is indeed the correct option. All the other ones make no sense with regards to changing the name. It is indeed D. That was one of the 3 requirements. So, hey, spot on. Hey, when you guys come to do this exam, we're going to be flying, man. Oh, that's going to be easy. Ooh, I didn't cover this one tonight. I didn't have time today to actually make up a little chart. I was trying to draw up a family tree, and I was color coding it, and I just ran out of time. So, but maybe if you guys have read this in the prescribed book, maybe you can give a try at it. But the question is, affinity in the direct line exists between you and your. Now there are 4 options. Option A is grandfather. Option B is grandchild. Option C is sister-in-law. Option D is mother-in-law. And affinity means by marriage, and then obviously direct lines. So let's go for it. Martha, I see you there, Martha.
Oh, sorry.
You can go for it.
I'll go for D, mother-in-law.
All right, so we've got 1 for D. Martha, you can talk. You just have to unmute your mic.
Oh, I didn't realize that I had raised my hand. But yeah, I'm also going with D. It's okay.
Oh, perfect. There we go. Hey, it's nice to get some new voices in here. All right, so we've got a couple there for D. Anybody else? We're going once, going twice. And yes, the answer is indeed D. And the reason being is affinity means relations by marriage, and then obviously the direct line of that person. So your sister, your grandchild and your grandfather obviously are on your side. Your sister-in-law is not in the direct line, but your mother-in-law is, because that would be your spouse's mother. So all those who said D, 100% spot on. All right, here's a nice short question as well. So which one of the following is not a requirement for the duty of support between spouses in a civil marriage? Option A is the person from whom the support is claimed must be able to provide it. Option B is the existence of a joint household. Option C is the person claiming the support must be in need of the support. And option D is a valid civil marriage. Now, remember, the question is asking for not a requirement, meaning there are 3 correct ones and 1 false one. Kunda, I see you've really got your hand up there.
Yep. I'm going to go with option B, and I'm leaving you guys. I'm out of time. Thank you so much.
All right. Hey, it was awesome to have you tonight. We'll see you on the study group. Right. Who else wants to give this one a go?
I'll also go with B.
B. Anybody else? We're going to do like going once, going up. How's that hand come in there? Yes, Martha, go for it. Oh, no, you can't put your hand down. I saw that hand. All right, so the correct answer in this one is indeed option B, because that's incorrect. So all those in the B camp, you guys got yourselves another gold shiny star. All right, I see it's now 10 to 9. Hopefully this is giving you guys a bit more practice. I do have a couple more questions, but I think maybe we can leave them for tomorrow night, just that you guys can at least enjoy the rest of your Friday evening. So tomorrow night we are going to be chatting about a divorce maintenance, and hopefully we can get through to the children's rights and responsibilities as well. Juliet, I see you've got your hand up.
Oh, Darren, I just discovered that I was in the wrong class. I thought it's PVL 2602. Are you also offering the classes for PVL 2602?
We haven't specifically done anything for that module. We'll have to look and see if we've got time for that, because this one's for family law 2601.
And I've done 2601 already.
Oh, no.
Oh, yes.
So it was a nice refresher course for you then, eh?
Yeah, it was.
We'll see about 2602. We haven't got anything penciled in for that, but if we do one, I will definitely let you know.
How will I get hold of you?
Are you on the WhatsApp study groups?
No.
All right.
Somebody send it to me. Yeah, I'm not.
Okay, so we'll pop it in the chat for you. I'm not sure if, let me just see if I can grab one here quickly for you.
Okay. Thank you. Much appreciated, sir. Thank you so much.
Just bear with me a moment. I'm just going on my phone quickly to pull up the link and I'll post it.
Okay.
But I assume this evening was able to help everyone. You learned something new, hopefully, and had a bit of fun as well. I see your hands up there, Kundai. I'm not sure if
Am
you
I
saw.
audible?
Yeah, yes, we can hear you.
Okay, awesome. Thank you. I'm back. False alarm. What was the answer? Sorry.
The answer was B, the existence of a
Oh,
joint
okay.
household.
Thank you.
I'm
Okay,
just
awesome. Thank you.
trying to quickly drop a link in, but technology being technology, I will, in the meantime, just hop across. Oh, we covered that one. Just while I'm busy trying to access the chat, just to drop this message. I see in the chat there, someone's asking the link is the same. Yes, we'll use the same link for tomorrow night as well. So you can just join on that one. We'll do it at 7 o'clock as well. Marapang, I see your hand is up. Do you have a question for us?
I wanted to confirm the time for tomorrow's class, but I think you have just answered it to say it's 7 o'clock. And then maybe to further comment and say we are thankful for this insightful work. Indeed, we really appreciate it. It has been insightful and we have learned a lot from this session. And thank you again.
No, it's awesome. As long as you guys are enjoying it, I don't mind it. I know Sean as well. He's also quite involved in helping out. So we enjoy helping you guys. We enjoy chatting with you guys as well. So for us, we enjoy it as well. But yes, tomorrow night, we'll use the same link as this. We will use 7 o'clock as well. I did drop the WhatsApp link in the chat now. If it's giving you an issue, you can just let me know, but hopefully you are able to click on that and go through the WhatsApp group. That link is for the WhatsApp community, the second year. So from there, you can join the PVL2602 group and the other groups as well. But yeah, let's maybe use this as our last question for the night, seeing that it is up. So parties married in accordance with the Civil Union Act may legally refer to their marriage relationship as, and we've got 4 options. The first one being a marriage or civil partnership. Option B being a civil partnership. Option C is a domestic partnership. And lastly, a marriage or a domestic partnership. Kundai, sure, your hands up first. Which one do you think is the correct option?
Option A.
Yay, A's in the camp again. Martha, you got your hand up. Which one do you think is the right one?
Oh, I'm sorry, I didn't realize that my mic was off. Definitely A.
Okay, cool. There we go. So we've got 2 A's. Who else wants to give their thing? This is the last question. So this is like last call for the night. Who else wants to like get in before we end for the night? Now's your chance. All right. So the correct option in this case is A. It can be referred to as a marriage or a civil partnership. So kudos to the guys in Camp A who chose A. You guys are all 100% spot on. And I was just looking quickly over the chat. Sure, A was definitely the winner in this one, hands down winning. Yeah. So hey, it looks like you guys are like on fire. You're ready for the exam. The exam can be tomorrow. Well, not tomorrow. We're going to do divorce and maintenance first, and then we can do the exam. But yeah, I will post the recording up, the link on the WhatsApp group, and I'll also upload it to YouTube. So once that's done, you guys can then go back and watch if you need to as well. Otherwise, I don't know if there's any last questions before we close for the evening. Yeah, it doesn't look like we have any questions. I have posted the link there for the WhatsApp group. If for whatever reason it doesn't work, just pop me a message or you can let us know tomorrow evening and we will see what's happening. But otherwise, it was awesome being here with you guys tonight. Hopefully it was fun and I will see you all on the study groups and tomorrow evening at 7. So have a super evening, everyone.
Thank you, Darren. Enjoy your evening too. Bye.
Thanks.
Thank you.
Thanks, Sean. It was fun
Much
tonight.
appreciated. Thank you.
All right.
Have a
Thanks,
good evening.
Darren. Thank you, everyone.
Bye bye.
Good